Hi, I go by name of Heinz, your friendly neighbor, Ketchup Man, and welcome back to the Ketchup Court Recap Show. This is a show that we're gonna go through the key. Let me just get my throat. I just lost my voice there for a second. This is a show that we go through the key moments of the trials that we cover on here, like we are doing today with the Mario Fernandez trial. This is a murder for hire case where Mario Fernandez, alongside his wife, Shanna Gardner, both of them has been basically been believed or alleged to have been in cahoots with one another to carry out the murder of Jared Bridegan, and we're now on trial for the first of many trials. There will be, I think there's 3 trials in this. I think Henry Tennant already pleaded guilty for one of it, and I believe he recanted. I'm not too sure. Don't hold me to that. But that's what I read on the press release for this particular case. Yes, so we are going to be covering day 3 because that's where we are at this current point in time. There were 4 witnesses that testified today. I believe it was 4 witnesses that testified today in the proceedings, and it was a lead detective, as well as friends of Mario from his childhood that grew up with him, etc., and a DNA analyst that gave testimony. So we are going to be going through all of that on today's show. So let's begin with the first witness that I want to go into, and he goes by the name of Chris Johns. This was the cross-examination that we were continuing from yesterday, because his testimony ended yesterday on the direct examination, and the cross-examination was supposed to start today. His cross-examination is still not over because he's going to be back tomorrow to complete the cross-examination, but due to scheduling and the other witnesses that they had to testify, that meant that Chris Johns had to be intermitted, if that's a word. Yeah, that meant that he had to be shuffled around. So we're gonna go into his testimony where he gave testimony saying that Shanna Gardner was where the defense brought, up a very good point, that Shanna Gardner was saying positive things about Jared Bridegan on the forums, and she did not want him to lose his children. So they're trying to show that there was no social alienation that was going on Shanna Gardner's side. That Shanna Gardner was trying to be accommodating towards Jared Bridegan. Let's go and take a listen to the testimony right now.
That's correct. Any kind of, let's just not beat around the bush. It was about scheduling for the most part, correct?
Well, things you would probably expect to find in a family chat.
Yeah. Medical decisions between the children?
Yes.
Pickups and drop-offs?
Yes.
Exchanging medical supplies or school supplies?
Yes.
Okay. And that comprised over years of information that you and your team were able to investigate. And you would agree sometimes there were little snips from one side or the other, right?
Correct.
Okay. But in all of that, there was nothing, as you've already told me today, that you can say, yeah, this went to motive, this went to violence, this went to why we believe Mr. Fernandez is involved in the crime, out of the thousands of messages that you read, correct?
That's correct.
Okay. Now I'm going to go back in history, and I'm going to show you Defense Exhibit 1B. This is the consent final judgment of dissolution of marriage. Okay? This is, in fact, the initial document that Jared Bridegan and Shanna Gardner agreed to regarding time sharing, or as the state uses, custody in this case. You agree with that?
Yes.
And you know, even with just limited family law knowledge, that a consent final judgment means both parties agreed.
Yes.
They didn't go to court and a judge said, after all this fighting, I give you X, I give you Y. These two parents for their 2 children, came to an agreement, and the agreement says, on page 4, page 4, section 7. No, go down to the pairing plan, sorry. So part of the consent final judgment is also their properties, what they do with their cars, what they do with their houses, correct?
Right.
And as part of the property, are you aware that Ms. Gardner was ordered to give Jared Bridegan $390,000?
I think it was part of their marital residence, but I don't know the specifics of their divorce.
Right, she got to keep the house. In exchange, she gave him $390,000 in cash.
Right.
Okay, just want to make sure you're aware of that. Now, where it says time sharing schedule, in section 7, you go down. Just be easier if I have them. Okay, see where it says in section B below, this schedule is intended to be a 50-50 time sharing schedule.
Yes.
Clear as day, they agreed to 50-50 back in 2015 by agreement of the parties.
Yes.
Okay. Now I want to show you what's been put into evidence as defense exhibit 1C.
So what we're going through right now is basically the
This is called a supplemental
agreement between
petition to modify
let me
time
pause
sharing
this quickly.
and support and other
So
issues.
what we're going through right now is the agreement that Shanna Gardner signed with Jared Bridegan during the divorce. So the state's theory is that this divorce was so acrimonious that it led to both Jared and his wife Shanna Gardner, who is another defendant. Her trial is gonna happen way later on, probably at the end of this month, and we're gonna be covering it as well. So they're basically showing that Shanna Gardner was not doing anything to jeopardize Jared Bridegan seeing the kids or anything like that. Let's take a listen.
Can you see that?
Yes.
So this is now Ms. Gardner going back to the court and saying, I'd like to change what we agreed to, right?
Correct.
Okay. And now, in the supplemental petition that was filed by Ms. Gardner, if you would go to page 3, paragraph 3. May I approach the hard copies just
Yes.
on the computer?
Let's speed this part up.
Abilities?
Yes.
Okay, my question was to you. This is Ms. Gardner going in and asking for a change, right?
Correct.
Read for the jury what Ms. Gardner, without the assistance of a lawyer, asked for the judge to do in modifying time sharing.
A more beneficial time sharing schedule for the children has been successfully utilized since June 2016 of 1 week on and 1 week off with a Wednesday date night.
Okay? So she's just asking for a different 50-50 time sharing schedule, correct?
She's asking for a modification to the time sharing agreement.
You have to agree with me that week on, week off is a 50-50 time sharing agreement.
Just reading what the document says.
I'm asking you. If you're with your children for 1 week, and then they're with the other side for another week, and then you're with them for 1 week, and you go a whole year or a whole lifetime, wouldn't you agree with me that's an equal time sharing schedule?
Yes.
Thank you. And in this particular case, and the jury has the ability to look at all this evidence because it's been admitted, it's been marked, and it's in, they can determine what the change was. So without going back, the last one, it was a few days in between, and now she was saying, let's just go a week on and a week off. And you would also agree that she's telling the court that they've already started doing it, and it's been successful since 2016. That's what she says, correct?
Based on the document, yes.
Okay. Wasn't trying to take away any time sharing from Mr. Bridegan.
Not according to this document, though.
Now, let's go to paragraph 5 of the same document, because now we've asked you about what she asked for. Now let's ask why she asked for it. Can you read paragraph 5 to the jury?
Schedule change has been agreed upon mutually because it allows them to have more stability for the majority of the time, as well as looking forward to a midweek visit with the opposite parent. Having the kids rotate homes every few days was too emotionally upsetting because it was too much instability for them to handle.
Sounds consistent with what she's asking for, correct?
Yes?
Did you know, because you've read the docket, that that's exactly what they did? That by agreement, without a judge having to get involved, they agreed to week on, week off with a Wednesday date night. Right?
Sure.
Right?
That's what it says, yes.
Yeah. Well, that's what you asked for, and then they actually came to an agreement to do that. Right?
Yes.
Now, in 2019, a few years later, Ms. Gardner files another supplemental petition, which has been marked in evidence as defense 1D. Can you see that?
Yes, sir.
Okay. Take as much time as you need to review it, but would you agree with me, after you've had time, that this supplemental petition doesn't seek to modify time sharing in any way, equal time sharing in any way?
Give me just a moment to read it.
Sure.
So I think
May I approach the witness?
let me see if I
I'll just
can
give you a
fast
full
forward a bit there because it's taking too long reading this. But yeah, I think
With me,
yeah,
Mr. Bridegan.
there we go.
In 2019, does Ms. Gardner seek to take away any time sharing from Mr. Bridegan?
It just discusses how they'll split up more holidays, and then there's a mention about their schools.
I'm going to ask you all about that.
Okay.
But I thought my question was pretty clear, so let me ask again. Do you agree, after reading that entire document, that nowhere in that document does Ms. Gardner seek to change equal time sharing with Mr. Bridegan?
No.
And that is crucial to go against what the state are proposing, because what they're proposing is that Shanna Gardner was being very difficult, and they were both this couple, both Shanna and Jared Bridegan, were having a tough divorce, a very hard divorce in which everything was contested. But right here, what he's showing is that actually there wasn't, on Shanna's end, she was actually quite supportive of Jared. And this is the part that I wanted. I finally got to a timestamp. This is what I wanted. This is where the defense even goes on to show that Shanna Gardner was even speaking positively of Jared Bridegan on the forms that they were filling out during the divorce. Now, again, this is very important to show that the divorce was just like any other divorce. It's similar to this. It's very similar. What they're doing is very similar to what Donna Elderson was, what her and her trial lawyers were doing, which was to show that the divorce was kind of mundane, like every other divorce, and they were just having a back and forth. There might be defense or something like that on Shanna Gardner's case. Maybe not on the Mario Fernandez case, because each one is more solicitation, and first, like, each one might not focus on the divorce as much. But anyway, let's listen to the testimony.
As is the mother's new husband. Both new spouses have strong and positive relationships with the minor children. This paragraph should not be construed as a personal attack on either step-parent.
She went out of her way to make sure that even with what they wrote in that paragraph, that no one would perceive it as a personal attack, right?
That's what it says, yes.
Ms. Gardner went out of her way to say that Ms. Bridegan is a positive influence in the children's lives, correct?
According to this document, yes.
That's all I'm asking you about. What's in
Yes.
That's all it says, is that she's a positive influence in their lives, correct?
Yes.
And she's saying that Mr. Fernandez is also a positive influence in their life. That's what the document says, correct?
Yes.
Right? And she's asking for the court to clarify their old parenting agreements that don't address step-parents, correct?
That's correct.
She didn't do this outside of court in a self-help mechanism. She went to the judge, she described what the issue was, and she asked for court intervention, correct?
That's correct.
Without personally attacking anybody, right?
According to the document, that's correct.
And without taking away a single second of time sharing from Mr. Bridegan, correct?
According to the document, yes.
Yeah. So
You keep saying according to the document. So let me ask you, what document are you
Okay.
going to tell me exists that's contrary to what I'm asking you? The whole docket's in evidence. Show me the court document that says that she took away time sharing from Mr. Bridegan.
I'm not aware of a document that says that.
Because it doesn't exist, right? That's why I'm walking you through this, to show that the documents that do exist show time and time again that they had an equal time sharing schedule that no one interfered with, correct?
Correct.
Okay, so again, that's important, and they are going to, and I believe a lot of the case will hinge on this moment. It will basically hinge on this divorce not being they will argue on this point because the cross examination, like I said earlier, it's not over yet. It's still ongoing. So, and they spent a lot of time to show, especially to show these documents, but also they spent a lot of time to show how Jared Bridegan was spending time with the assailants, and John Bigglestaff, who was apparently supposed to be involved in this, and Henry Tennant after the fact. So they were spending time. They were basically going through all of that to show that there was no cover-up or there was no collusion going on, because if there was, the last thing you want to be doing is speaking to the people that you know that you commissioned to commit the murder. And that's why I believe that they were going through all of that today. We're not gonna go through we're not gonna go through everything that they were showing, just some bits. And yeah, so the next part of the testimony that we're gonna go into is where I think, if you joined us yesterday, right, we showed the interview between the detectives and Mario Fernandez, and something that happened on that interview was that Mario Fernandez blurted out that why did Jared get out of the car? And I thought that was very, very peculiar at the time. And the defense attorneys, they also thought so too, because they were trying to clean up that part by saying that he was offering facts that were not really exposed to the public. Because I personally thought that this was not known to the public. How would he know that not Mario Fernandez? How would Mario Fernandez know that Jared Bridegan got out of the car to speak with the assailants, etc.? How would he know that? So this was a moment during the trial that my jaw dropped, because I didn't think I would think leave it alone. I didn't think that the defense were going to highlight this point. Let's go and take a listen.
Interview where they shouldn't know that detail, correct? Let me ask a better question. Sometimes there are details about a crime scene that only people that were at the crime scene are aware of. Do you agree with that?
Yes.
Okay. And sometimes when people give interviews, they oust themselves by accident, revealing a detail that only somebody at the crime scene or law enforcement would know, correct?
That's correct.
Okay. When Mr. Fernandez was interviewed, it was a couple weeks after the homicide?
Yes.
An important detail that this jury should know is that you had not released to the media that the tire was in the road. That was not public information.
I do know it was released eventually. I don't remember the exact timeline that it was released.
Okay. I'm not concerned about when it was released.
Okay.
What I'm concerned about is that at the time Mr. Fernandez was interviewed, you know that it had not been released at that point.
Correct.
That's what I'm asking you. So when he's saying, I don't know why he would get out of the car, he doesn't know that there was a tire in the road, correct?
I don't know I can't testify to what he knows or doesn't know.
He doesn't say anything about a tire, correct?
Not during the interview, no.
Right. He says something about maybe he knew the person in front of him, or maybe I just can't imagine why he didn't run him over. He gives all sorts of hypotheticals as to what happened, but he never mentions that there's a blockade or a tire or anything obstructing the roadway. Never even suggests that at all, correct?
That's correct.
Okay.
I'm so sorry. I meant to ask you that question and I forgot.
Okay. I think I just got it. Okay. It just hit me what it was trying to do. And now, at first, I thought it was a high-risk strategy. What he's doing by highlighting this, that he was bringing up details that was not privy to the public, because he was bringing up details that were not privy to the public, like Jared getting out of the car. That was not privy to the public, but he brought it up in such a way, in a masterful way, that he brought it up in a way to basically suggest that how do I say it? He brought what he brought up was to basically show that he could have said, although that he said this and that data wasn't privy to the public, he didn't give this detail. I still think he didn't give the detail, and the detail that he didn't give was the tire being on the road. That was the detail that he wanted to get into the jury's minds, that if he was really culpable of this, if he was really there, he would have mentioned the tire because he was speaking expressively, etc. But I do have a counter. I'm going to wager him, and I'm going to say, what about the moments during the interview that we watched yesterday? What about the moment in which he paused when he said when he mentioned Jared Bridegan getting out of the car? Because there was a long pause in that moment, and now we are watching this, and he's going through that moment without considering that there could be so much influences from that pause alone. Is what I'm trying to say. There could be so much to infer from that pause. There could be so much that that could be destructive by him going to make this point. And I don't think he needed to be made. So that this is probably the one moment in the trial that I wish he didn't do, because is putting your client at risk. But anyway, I'll leave it there, because, like I said, a lot of the testimonies was about a lot of the testimony to do with Chris Johns, which is going to continue tomorrow, was to do with it was to do with Mario Fernandez being at Henry Tennant's vehicle. It was to do with Mario Fernandez knowing John Biggerstaff, who has something to do with this case. And we have to wait for the evidence to unfold. There's still wiretaps to go through, etc. So the next witness that we're going to go into goes by the name of Taylor Curtis, who was a friend of the defendant. I'm not sure if she's still friends now. And what she testified to is that Mario Fernandez used to trust her with some of the details with Shanna Gardner, his wife. So they also used to hook up as well. That's what came out on cross-examination, that they used to hook up as well, and they basically had a friendship. And Mario Fernandez would tell her some things. So on the day of the murder, this is what she was called in for, because she knows something that happened on the day of the murder, which was because Mario Fernandez had basically called her. Let's listen to that testimony right now.
I don't have exact dates.
That's fine. I'm not going to hold you to an exact date.
Okay.
We're not human calendars. I get that. When you spoke to him the last time or few times, did he ask to visit you in person?
He did mention visiting in person, yes.
And did you ever actually meet up with him in person?
No, we did not.
Did Mr. Fernandez in 2022 call you and tell you about the death of his wife's ex-husband?
Yes, he did.
Do you recall when he called you in relation to when the homicide occurred?
It was after he called me we were talking, kind of chatting, catching up about work. Can't remember the exact context of the beginning of the call. And then he said that he thought that the kid's dad had died, and he thinks that it was a hit and run, was what he told me specifically.
And do you remember how close in time that was? Was it the day after, a few days, weeks, months?
I believe that it was a few days after, but I'm not exact on that. But I know it was after it happened.
Did he give any more details other than it was a hit and run?
No, he did not.
Right. Thank you, Ms. Kudis. I don't have any further questions.
All right, thank you. Cross-examination.
And that's it. And I just want to highlight the importance of that testimony, because him saying that it was a hit and run to Shanna, to Miss Taylor Kudis, that's why she's brought in, because that's not what she told the police. That's not what he told. That's not the detail that we learned yesterday from his police interview. We learned yesterday that this was that he knew that there was a tire on the road, and he got out of the car. He didn't know there was a tire on the road. My bad. That's my insertion. He got out of the car, and he shouldn't have got out of the car. That's what he said to the detectives on the 1st of March interview. Why would he say that when the detectives didn't have any public information out about the case is a mystery. But that's what he said. But speaking with Taylor Kudis, not Shanna Kudis, Taylor Kudis, speaking with her, and the testimony that she just provided is suggesting that he's now saying to Taylor that it was a hit and run. How would he know it was a hit and run? And why are we having multiple different versions of the same story? It's not like he's speculating. How would that impact it? Like that detail about it being a hit and run, it just suggests to me that he knows that it was like a drive-by shooting kind of way, because that can be classified as a hit and run as well. That's what it suggests to me. That's what it suggests to me. So that was a pretty key testimony from Shanna Kudis. The next witness, we're not gonna go through a video or anything, but it goes by the name of Victor Kouros, who was testifying, who testified as well. He just basically testified that I forgot his name, Mario Fernandez. Gosh, anyway, he just testified that Mario Fernandez and him used to play video games, and that's how they met. He also testified that when Jared Bridegan died, that Mario Fernandez never really filled him in all that he did. So that was the bulk of his testimony, that he never filled him in about the stepdad of his stepchildren, the dad of the stepchildren, that he never filled him in that he died. So that was the bulk of testimony. I didn't really see much use or much reason for his testimony. I don't know what he was trying to do there, but nonetheless, that's what he testified to. So then the next witness that I want to go into, it goes by the name of Glenn Ferrick, and he was the forensic biologist. He conducted the testings for the items that were recovered from the scene, and this is what he had to say in regards to the shell casings that were recovered from the scene.
I'm going to talk about the shell casings number 3 and shell casings number 4 did you find that there was an inclusion with regard to the victim, in this case, Jared Bridegan?
So those items in question, these are two 10 millimeter cartridge cases recovered from the scene, assigned lab exhibits 3 and 4. We will sample cartridge cases in pairs on occasion, which is what was done in this case. So lab exhibits 3 and 4 were sampled together. That resulted in lab exhibit 3.1. That sample was processed and there was a profile obtained from exhibit 3.1 consistent with being a male DNA profile consistent with a single contributor. Upon comparison to the reference samples in this case, there was support for inclusion of Jared Bridegan as a possible contributor to that DNA profile.
Was there a statistical component that you would assign to show, to give the jury an idea of how forensically important that inclusion was?
So when we report any conclusion as a result of a comparison that is anything other than exclusion, we will report a statistic that is known as a likelihood ratio. A likelihood ratio is a value that can give weight or give support to either inclusion or exclusion of an individual. It is an assessment of how probable the evidence profile is under different possible explanations. One explanation is what we call the inclusionary hypothesis, and this is where we assume that the person we're comparing is a contributor to the profile. The other explanation is what we call the exclusionary hypothesis. This is where we propose that the person of interest is not a contributor, that other unrelated unknown individuals could be the contributor. So when we do the comparison between Jared Bridegan and Exhibit 3.1, the likelihood ratio value is that it is at least 1 trillion times more likely to observe the evidence profile from Exhibit 3.1 if Jared Bridegan is the contributor than if an unknown, unrelated individual is the contributor.
I'm showing you what's been entered into evidence as State's Exhibit 94. You can see on your screen, State's Exhibit 88C and 88D. You see those? I know they're all bunched together, beginning first with 94. This has been introduced into evidence as the victim's blood spot card. Is that where you developed the full profile from Jared Bridegan? If it's easier for me to just show it to you the whole.
Maybe if I look at it myself, yes.
I don't know why I'm saving steps.
It may be useful at this juncture to point out that at our laboratory, as the forensic biologist, I won't necessarily do all the work in the case myself. We do have lab specialists that assist us with laboratory tasks, and sometimes examiners will do various laboratory tasks for each other. I'm the one who's responsible for all the analysis of the data and the reporting. And I bring that up because I see this exhibit, which is ATF and also lab exhibit 18, which is the reference sample from Jared Bridegan. This is not a sample that I actually received myself, but I do see the handwritten initials of the lab specialist that did process this item.
Okay, and I'm showing you 88C and 88D, the shell casings. Now, my understanding is those shell cases were processed to extract DNA different from the normal swabbing. Is that true?
That is correct. At our laboratory, we use a specialized sampling technique known as the rinse and swab technique to recover DNA from fired cartridge cases. It is a technique that we developed in-house, and we published our research in a peer-reviewed research journal. As I look at these evidence packages, I see the lab specialist handwritten annotation indicating these are lab exhibits 1 and 4 that correspond to 2 of the 10 millimeter cartridge cases.
Okay, so I think that's all I wanted from that. That's all the testimony to do with the cartridge casings. The next part that he testified to is a swab from the pickup truck, and what they're finding from that. Let's listen to that testimony.
The likelihood ratio value for that comparison was that it was 1.38 million times more likely to observe the DNA profile from Exhibit 11.1 if Mr. Tinnen were a contributor with an unknown, unrelated individual than if it came from 2 unrelated, unknown individuals.
Okay, turn to the swab of the keys, the silver key that you took. Did you include Henry Tinnen as a possible contributor to that silver key swab, number 30?
Lab Exhibit 30 was the silver truck key, the sample that we took and generated the profile from. Lab Exhibit 30.1. That was characterized as a DNA profile consistent with 2 contributors with at least 1 male present, and that was suitable for comparison. Upon comparison with Mr. Tinnen's reference sample, there was support for inclusion of Mr. Tinnen as a possible contributor to that profile. The likelihood ratio was that it was at least 1 trillion times more likely to observe the DNA profile from Exhibit 30.1 if Mr. Tinnen was a contributor with an unknown, unrelated individual than if it came from 2 unrelated, unknown individuals.
Turning to states, 33.4, the cutting from the steering wheel, were you able to include Henry Tenen as a contributor to that?
Lab Exhibit 33.4 corresponds to a swab from the steering wheel of a pickup truck. That profile was a partial profile consistent with one individual. That was suitable for comparison. Upon comparison to Mr. Tenen's reference sample, there was support for inclusion of Mr. Tenen. The likelihood ratio was that the DNA profile is at least 1 trillion times more likely if it originated from Henry Tenen than if it originated from an unknown, unrelated individual.
We'll do the same process. May I please?
Yes, you're out.
Thank you. States Exhibit 9, we'll start first with States Exhibit 95. Is this the reference sample from Mr. Henry Tenen that you or your fellow lab people worked on?
This sample I did initial myself, and I see our lab inscription and lab number. This is Exhibit 26, the reference sample from Henry Tenen.
Okay, and that's going to be States Exhibit 95. All right, States Exhibit 92 is going to be the swab from the inside rim of the tire.
All right, I see the handwritten inscription from the lab specialist who assisted with this case. This is Lab Exhibit 11, the swab taken from the inner rim of the tire.
States Exhibit 193 is going to be the swab from the silver key.
I see the handwritten annotation from the lab specialist, and this is Exhibit 30, the swab from the silver Ford truck key.
States Exhibit 169 is going to be the swab from the steering wheel.
I see my handwritten information. This is Exhibit 33, 4 of 13. There were 13 swabs submitted as part of Exhibit 33, and this is number 4 of 13, which corresponds to the swab of the steering wheel.
Sir, I appreciate your testimony. I have no further questions at this time.
Thank you.
Okay, so that's
Just briefly, Your Honor, Matt Dewar from Defense Table.
That's fine.
Good afternoon, sir.
Good afternoon.
I didn't catch, where did you come in from?
I work at the Forensic Science Lab, Washington, which is located in Maryland, just outside D.C.
You flew in today, sir?
I came in yesterday afternoon.
Welcome, Jackson. I just want to make sure the jury's clear. You found nothing to include Mario Fernandez, is that correct?
Of the profiles that were suitable for comparison, there was no support for inclusion of Mr. Fernandez-Saldana as a possible contributor to any of those profile components suitable for comparison.
Thank you, sir. I have no further questions.
All right. Any follow-up?
No, Your Honor.
Okay.
okay. So pretty standard question. I'm pretty much guessing that they just want to get into jurors' heads there that there was no way that Mario could have been at the truck because his DNA would have been lifted from the truck. But then again, it was DNA from the tire. It was DNA from the steering wheel. So Mario was not driving, nor was he a passenger. There was nothing really from the scene that could have included Mario Fernandez. So that's why I'm guessing that question was asked. But that's pretty much all I wanted from that testimony. There's so much of the trial to go that there is no predicting it. Today was pretty much long and mundane. A lot of it was spent on the lead detective, and I predict tomorrow will be the same thing. But we might be seeing the closing, the winding down of the lead of Chris John's testimony, who was the lead detective. He's going to be testifying tomorrow. We might hear testimony in regards to the wiretaps that might be done. There's so much more of this case to go, and I cannot wait to come back tomorrow and do this recap with you guys. Hopefully you have enjoyed it. If you're watching live with us, make sure you hit the like button, and also if you haven't subscribed yet, make sure you subscribe for the case coverage that we do on this channel. If you're watching on replay, hi. Hopefully you have enjoyed what we have tried to show today, and you have found some value from this show. We'll be back tomorrow to discuss this case and recap on day 4. I'll leave it there for now. Take good care of yourselves. Have a great evening or day wherever you're at. Bye for now, and most importantly, stay saucy. Thank you everyone for tuning in for another Catch Up Call live stream. make sure that you smash that like button as well as hitting that subscribe button to be notified of our future live streams. We go live regularly, bringing you case updates and recaps of ongoing trials, so make sure you hurry back on the next live stream. We also have more content on the channel that you can binge on. Check out the playlist that we have showcasing all of these contents. Without further, I go by the name of Heinz.